first issue is the issue of majoritarianism. I'm not going to give the whole detail. Everybody in the labour relations field knows exactly what I'm talking about. Winner takes all within the strike scenario, within the work scenario with the trade unions. And in particular, Section 18 of the Labour Relations Act, which provides that a company and a majority union can reach an agreement setting the levels for representativity by trade unions for organizational rights, particularly the right to access to the workplace and also the issue of check-off facilities. This has led, as I'm sure all of you are very well aware, to inter-union rivalry. It has led to scenarios where a union that could have 40% representativity in a workplace do not have organizational rights because of this Section 18. Last week, the Parliament, and in particular the National Assembly, passed the Labour Relations Amendment Bill of 2014. And one issue there is very, very important, and it's going to be very interesting to see what the impact of this particular amendment is going to have around the issue of majoritarianism going forward. In essence, it says that where you have a Section 18 agreement in place, and there's another union that would like to have access and check-off facilities. This union goes to the CCMA, conciliation, ends up with arbitration. This union can now ask the arbitrator to look at this particular issue, and the arbitrator will be prepared, or in terms of the law, empowered to look at this issue. And what the arbitrator will have to do is, one, ensure that all the other parties are present at the arbitration. So this would be the employer and the majority union that concluded the agreement. They must be there. And then the applicant union, if that applicant union can indicate that it represents a significant interest in that workplace, or it has a substantial number of employees as members, the arbitrator can take this into account and then afford that particular trade union access and check-off facilities. I think this is a very important amendment to the Labour Relations Act, and I would really like to hear people's views on this, and I would like to see what the impact of this is going to be going forward.
To get to a next item, and that's the majoritarian principle. I know Elize alluded to it, but with the signing of the framework agreement for a sustainable mining industry, that was the initiative of Deputy President Kgalema Motlanthe to put us on a 12-month path to get to a stable mining environment. And at the time when we were negotiating it, all parties, including AMCU, bought into the principle that the majoritarian principle, as stipulated in Section 18 of the Labour Relations Act, should be phased out. In other words, abolished. There was a time for it. When it was introduced way back, and I was still working for the Department of Constitutional Development and part of the negotiations on the government side, that was a political settlement, Section 18. But so it served its purpose, but now we got to a point where we say all parties acknowledge that the underlying reason, or one of the underlying reasons of the labour unrest is the majoritarian principle. We also said in clause 5.3 that it may be unconstitutional because you take the right of freedom of association away. So AMCU sat in that last evening when we concluded the final draft. They've agreed to it. They were there with the legal team. They've agreed to it. The fact that they didn't sign it wasn't as a result of that clause. So government, business, and all the unions agreed to it. So that's why we believe it's a major setback when Lonman went and they signed that recognition agreement with AMCU. It is a major setback for the credibility of the framework agreement, and also it now is a setback for peace and stability.